Let's get started with special contracts from Indian Contract Act, law relating to agency. Before that, if you're watching my video without subscribing to my channel, do subscribe and like the video. It motivates us to upload more. This channel runs on without monetization. We don't earn any income. My only purpose, I opened this channel to share knowledge among students to score good marks. All I need is your support, so subscribe and like my video. Introduction. A relationship of agency is established when one party, agent, is authorized by another party, principal, to act on his/her behalf. Such relationships are initiated when one party desires to extend his/her activities beyond his/her present limits or capacity. In modern life, it would be impossible for a man to do everything by himself. Thus, he needs agents to perform activities. A relationship of agency is commonly visible in all business transactions. These include hiring employees or retaining the services of other professionals such as an attorney, design professional, software developer, etc. An agent has the potential to form contracts on behalf of the principal, and in doing so, will bind the principal. As a result, the relationship of agency is one of trust and confidence, and an agent must perform his/her activities in a capable and conscientious manner. The law of agency is contained in sections 182 to 238 of the Indian Contract Act. Let's see what is agency. The Indian Contract Act does not define the word agency. However, Section 182 of the Indian Contract Act defines agent and principal as: agent means a person employed to do any act for another or to represent another in dealing with the third persons, and the principal means a person for whom such act is done or who is so represented. Test of agency: whether the person has the capacity to bind the principal and make him answerable to the third party. Whether he can establish privity of contract between the principal and third parties. If the answer to these questions is in affirmative, yes, then there is a relationship of agency. Thus, agency is a comprehensive word used to describe the relationship between one person and another, where the first mentioned person brings the second mentioned person into legal relation with others. The rule of agency is based on the maxim qui facit per alium, facit per esse, that is, he who acts through an agent is himself acting. Appointment and authority of agents. Who may employ an agent? According to Section 183, any person who has attained majority according to the law to which he is subject, and who is of sound mind, may employ an agent. Thus, a minor or a person of unsound mind cannot appoint an agent. Who may be an agent? Section 184 provides that as between the principal and third persons any person may become an agent, but no person who is not of the age of majority and of sound mind can become an agent, so as to be responsible to his principal according to the provisions in that behalf herein contained. Thus, according to Section 184 of the Act, any person may become an agent, that is, even a minor or a person of unsound mind may become an agent, and the principal shall be bound by his acts. But as a rule of caution, a minor or a person of unsound mind should not be appointed as an agent because he is incompetent to contract, and in case of his misconduct or negligence, the principal shall not be able to proceed against him. Example: Mr. P appoints Mr. Q, a minor, to sell his car for not less than Rs. 2,50,000. Mr. Q sells it for Rs. 2,000,000. Mr. P will be held bound by the transaction, and further shall have no right against Mr. Q for claiming the compensation for having not obeyed the instructions, since Mr. Q is a minor and a contract with a minor is void ab initio. Consideration not necessary. According to Section 185, no consideration is necessary to create an agency. The acceptance of the office of an agent is regarded as a sufficient consideration for the appointment. Modes of creation of agency. According to Desai of the Supreme Court of India, the relation of agency arises whenever one person called the agent has the authority to act on behalf of another called the principal and consents to act. The relationship has genesis in a contract. The relationship of the principal and the agent may be created in any of the following ways. Express appointment, which is words. spoken, written, implied appointment, necessity, estoppel or holding out, agency by ratification. The authority may be express or implied. According to Section 186, the authority of an agent may be express or implied. Definitions of express and implied authority. Section 187. Express authority. An authority is said to be express when it is given by words, spoken or written. Implied authority. An authority is said to be implied when it is to be inferred from the circumstances of the case, conduct of the parties and things spoken or written, or in the ordinary course of dealing, may be accounted from the circumstances of the case. Next. Agency by estoppel. Section 237. An agency by estoppel is based on the principle of estoppel. The principle of estoppel lays down that when one person by declaration, representation, act, or omission has intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, he shall not be allowed to deny his previous statement, or he shall be stopped to deny his previous statement or conduct. The agency by estoppel is provided under Section 237 of the Indian Contract Act. Section 237 states, when an agent has without authority done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by such acts or obligations if he has by his words or conduct induced such third persons to believe that such acts and obligations were within the scope of the agent's authority. According to Section 237 of the Contract Act, an agency by estoppel may be created when following essentials are fulfilled. 1. The principal must have made a representation. 2. The representation may be express or implied. 3. The representation must state that the agent has an authority to do certain act although really he has no authority. 4. The principal must have induced the third person by such representation, and 5. The third person must have believed the representation and made the contract on the belief of such representation. Necessity. An agency of necessity arises due to some emergent circumstances. In emergency, a person is authorized to do what he cannot do in ordinary circumstances. Thus, where an agent is authorized to do certain act, and while doing such an act, an emergency arises, he acquires an extraordinary or special authority to prevent his principal from loss. Next. Ratification. Rights of person as to acts done for him without his authority. Effect of ratification. Section 196. Where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts. If he ratifies them, the same effects will follow as if they had been performed by his authority. In simple words, ratification means approving a previous act or transaction. Ratification may be express or implied by the conduct of the person on whose behalf the act was done. Essentials of a valid ratification. 1. Ratification may be expressed or implied. Section 197. Ratification may be expressed or may be implied in the conduct of the person on whose behalf the acts are done. Example. Mr.A, without Mr.B's authority, lends Mr.B's money to Mr.C. Afterwards Mr.B accepts interests on the money from Mr.C. Mr.B's conduct implies a ratification of the loan. 2. Knowledge requisite for valid ratification. Section 198. No valid ratification can be made by a person whose knowledge of the facts of the case is materially defective. Example. Mr.A has an authority from Mr.P to buy certain goods at the market rate. He buys at a higher rate but Mr.P accepts the purchase. Afterwards Mr.P comes to know that the goods purchased by Mr.A for Mr.P belong to Mr.A himself. The ratification is not binding on Mr.P. If, however, the alleged principal is prepared to take the risk of what the purported agent has done, he can choose to ratify without full knowledge of facts. 3. Effect of ratifying unauthorized act forming part of a transaction. Section 199. A person ratifying any unauthorized act done on his Behalf ratifies the whole of the transaction of which such act formed a part. There can be ratification of an act in entirely or its rejection in entirely. The principal cannot ratify a part of the transaction which is beneficial to him and reject the rest. 4. Ratification of unauthorized act cannot injure third person. Section 200. An act done by one person on behalf of another, without such other person's authority, which, if done with authority, would have the effect of subjecting a third person to damages, or of terminating any right or interest of a third person, cannot, by ratification, be made to have such effect. In other words, when the interest of third parties is affected, the principle of ratification does not apply. Ratification cannot relate back to the date of contract if third party has in the intervening time acquired rights. Example: Mr.A, not being authorized thereto by Mr.B, demands on behalf of Mr.B, the delivery of a chattel, the property of Mr.B, from Mr.C, who is in possession of it. This demand cannot be ratified by Mr.B, so as to make Mr.C liable for damages for his refusal to deliver. 5. Ratification within reasonable time. Ratification must be made within a reasonable period of time. 6. Communication of ratification. Ratification must be communicated to the other party. 7. Act to be ratified must be valid. Act to be ratified should not be void or illegal, for example payment of dividend out of capital, forgery of signatures, any other criminal offense, or anything which is not permitted under law. Extent of agent's authority. The authority of an agent means his capacity to bind the principal to third parties. The agent can bind the principal only if he acts within the scope of his authority. The extent of an agent's authority, whether expressed or implied, is determined by the nature of the act or the business he is appointed to do. Things which are incidental to the business or are usually done in the course of such business. The usage of trade or business. Whatever be the nature or extent of the agent's authority, it will always include the authority to do every lawful thing necessary for the purpose of carrying it out. Every lawful thing justified by various customs of trades. In an emergency, all such acts for the purpose of protecting the principal from loss as will be done by a person of ordinary prudence in his own case under similar circumstances. The agent's authority is governed by two principles, namely, in normal circumstances and in emergency. Agent's authority in normal circumstances. Section 188. An agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. An agent having an authority to carry on a business has authority to do every lawful thing necessary for the purpose, or usually done in the course, of conducting such business. Agent's authority in an emergency. Section 189. An agent has authority, in an emergency, to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence, in his own case, under similar circumstances. To constitute a valid agency in an emergency, following conditions must be satisfied. Agent should not be in a position or have any opportunity to communicate with his principal within the time available. There should have been actual and definite commercial necessity for the agent to act promptly. The agent should have acted bona fide and for the benefit of the principal. The agent should have adopted the most reasonable and practicable course under the circumstances, and the agent must have been in possession of the goods belonging to his principal and which are the subject of contract. Subagents. When agent cannot delegate. Section 190. An agent cannot lawfully employ another to perform acts which he has expressly or impliedly undertaken to perform personally, unless by the ordinary custom of trade a subagent may, or from the nature of the agency, a subagent must, be employed. Subagent defines. Section 191. A subagent is a person employed by, and acting under the control of, the original agent in the business of the agency. Subagency refers to case where an agent appoints another agent. The appointment of subagent is not lawful, because the agent is a delegatee and a delegatee cannot further delegate. This is based on the Latin principle delegatus non potest delegare. A contract of agency is of a fiduciary character. It is based on the confidence reposed by the principal in the agent, and that is why a delegatee cannot further delegate. Exception where an agent can appoint subagent. 1. The appointment of a subagent would be valid if the terms of appointment originally contemplated it. 2. Sometimes customs of the trade may provide for appointment of subagents. In both these cases the subagent would be treated as the agent of the principal. 3. Where in the course of the agent's employment, unforeseen emergency arise making it necessary for him to delegate the authority that was given to him by the principal. Representation of principal by subagent properly appointed. Section 192. Where a subagent is properly appointed. 1. The principal is, so far as regards third persons, is bound and responsible for the acts of subagent as if he were an agent originally appointed by the principal. 2. Agent's responsibility for subagents. The agent is responsible to the principal for the acts of the subagent. 3. Subagent's liability to principal. The subagent is responsible for his acts to the agent, but not to the principal, except in case of fraud or willful wrong. Agent's responsibility for subagent appointed without authority. Section 193. Where an agent, without having authority to do so, has appointed a person to act as a subagent. 1. The agent stands towards such person in the relation of a principal to an agent, and is responsible for his acts both to the principal and to third persons. 2. The principal is not represented by or responsible for the acts of the subagent. The subagent is not responsible to the principal at all. He is answerable only to the agent. Where the subagent is properly appointed. Where a subagent is properly appointed, the principal is bound by his acts and is therefore responsible to third parties as if he were an agent originally appointed by the principal. In the case of appointment without authority. In case where the appointment of subagent takes place without authority, the principal is not bound by the acts of subagent and subagent is not answerable to the principal. It is the agent who is the principal of subagent. Where the subagent purportedly acts in the name of first principal, that first principal may ratify the act of subagent. However, if the subagent acts in his own name or in the name of the agent who has without authority delegated to the subagent the business which is in fact of the principal cannot ratify such acts of subagent. Substituted agent. Substituted agent is a person appointed by the agent to act for the principal, in the business of agency, with the knowledge and consent of the principal. Substituted agents are not subagents. They are agents of the principal. Relation between principal and person duly appointed by agent to act in business of agency. Section 194. Where an agent, holding an express or implied authority to name another person to act for the principal in the business of the agency, has named another person accordingly, such person is not a subagent, but an agent of the principal for such part of the business of the agency as is entrusted to him. Agent's duty in naming such person. Section 195. In selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case, and, if he does this, he is not responsible to the principal for the acts or negligence of the agent so selected. Duties and obligations of an agent. Duty to execute mandate. The first and foremost duty of every agent is to carry out the mandate of his principal. He should perform the work for which he has been appointed. Any failure in this respect would make the agent absolutely responsible for the principal's loss. In Pannalal Junkidas vs Mohanlal, a commission agent purchased goods for his principal and stored them in a godown, pending their dispatch. The agent was under instruction to insure them. He actually charged the premium for insurance but failed to insure the goods. The goods were lost in an explosion on Bombay Harbour. The agent was held liable to compensate the principal for his loss minus the amount received under the Bombay Explosion Compensation Ordinance. conduct business in accordance with the directions given by the principal. According to Section 211, an agent is bound to conduct the business of his principal according to the direction given by the principal, or, in the absence of any such directions, according to the customs which prevails in doing business of the same kind at the place where the agent conducts such business. When the agent acts otherwise and any loss is sustained by the principal, he must indemnify him, and, if any profit accrues, he must account for it. Duty of reasonable care and skill. According to Section 212, an agent is bound to conduct the business of the principal with as much skill as is generally possessed by persons engaged in similar business, unless the principal has notice of his want of skill. The agent is always bound to act with reasonable diligence, and to use such skill as he possesses, and to make compensation to his principal in respect of the direct consequences of his own neglect, want of skill or misconduct, but not in respect of loss of damage which are indirectly or remotely caused by such neglect, want of skill or misconduct. Agent's duty to communicate with principal. Section 214. It is the duty of an agent, in cases of difficulty, to use all reasonable diligence in communicating with his principal, and in seeking to obtain his instructions. Duty to avoid conflict of interest. Duty not to deal on his own account. Right of principal when agent deals, on his own account, in business of agency without principal's consent. According to Section 215. If an agent deals on his own account in the business of the agency, without first obtaining the consent of his principal and acquainting him with all material circumstances which have come to his own knowledge on the subject, the principal may repudiate the transaction, if the case shows either that any material fact has been dishonestly concealed from him by the agent, or that the dealings of the agent have been disadvantageous to him. Principal's right to benefit gained by agent dealing on his account in business of agency. According to Section 216, if an agent, without the knowledge of his principal, deals in the business of the agency on his own account instead of on account of his principal, the principal is entitled to claim from the agent any benefit which may have resulted to him from the transaction. Duty not to make secret profits. It is the duty of an agent not to make any secret profit in the business of agency. His relationship with the principal is of fiduciary nature, and this requires absolute good faith in the conduct of agency. Secret profit means any advantage obtained by the agent over and above his agreed remuneration, and which he would not have been able to make but for his position as agent. Duty to render proper accounts. Section 213. An agent is bound to render proper accounts to his principal on demand. Rendering accounts does not mean showing the accounts but the accounts supported by vouchers. Refer case study, Anand Prasad vs. Dvarkanath. Duty not to delegate. According to Section 190. An agent cannot lawfully employ to perform acts which he has expressly or impliedly undertaken to perform personally, unless by the ordinary custom of trade a sub-agent may, or, from the nature of agency, a sub-agent, must be employed. Agent's duty to pay sums received for principal. Section 218. Subject to such deductions, the agent is bound to pay to his principal all sums received on his account. Duty not to use any confidential information received in the course of agency against the principal. Rights of an agent. Right of retain out of sums received on principal's account. Section 217. This section empowers the agent to retain, out of any sums received on account of the principal in the business of the agency, for the following payments: all monies due to himself in respect of advances made, in respect of expenses properly incurred by him in conducting such business, such remuneration as may be payable to him for acting as agent. The right can be exercised on any sums received on account of the principal in the business of agency. Right to remuneration. Section 219. The agent in the normal course is entitled for remuneration as per the contract. In the absence of any agreed amount of remuneration, he is entitled for usual remuneration which is customary in the business. However, an agent who is guilty of misconduct in the business of the agency is not entitled to any remuneration in respect of that part of the business which he has misconducted. Section 220. Agent's lien on principal's property. Section 221. In the absence of any contract to the contrary, an agent is entitled to retain the goods, papers, and other property, whether movable or immovable, of the principal received by him, until the amount due to himself for commission, disbursement, and services in respect of the same has been paid or accounted for him. The conditions of this right are: the agent should be lawfully entitled to receive from the principal a sum of money by way of commission earned or disbursement made or services rendered in the proper execution of the business of agency. The property over which the lien is to be exercised should belong to the principal, and it should have been received by the agent in his capacity and during the course of his ordinary duties as an agent. If the agent obtains possession of the property by unlawful means, he cannot exercise particular lien. The agent's right to lien is lost in the following cases: when the possession of the property is lost, when the agent waives his right. Waiver may arise out of agreement express or implied. The agent's lien is subject to a contract to the contrary. Right to indemnity. Right of indemnification for lawful acts, Section 222. The principal is bound to indemnify the agent against all consequences of lawful acts done in exercise of his authority. The right to indemnity extends to all losses and expenses incurred by the agent in the conduct of the business. Where, for example, a stockbroker, on the instructions of a solicitor, contracted to sell certain shares and had to incur liability to the purchaser by reason of the owner's refusal to complete the sale, the stockbroker was held to be entitled to recover indemnity from the principal. Right of indemnification against acts done in good faith, Section 223. Where the agent acts in good faith on the instruction of principal, agent is entitled for indemnification of any loss or damage from the principal. Non-liability of employer of agent to do a criminal act. According to Section 224, where one person employs another to do an act which is criminal, the employer is not liable to the agent, either upon an express or an implied promise, to indemnify him against the consequences of that act. Right to compensation for injury caused by principal's neglect, Section 225. Section 225 provides that the principal must compensate his agent in respect of injury caused to such agent due to principal's neglect or want of skill. Thus, every principal owes to his agent the duty of care, and not to expose him to unreasonable risks. Principal's liability to third parties. An agent does all acts on behalf of the principal but incurs no personal liability. The liability remains that of the principal unless there is a contract to the contrary. This is because there is no privity of contract and passing of consideration between the agent and third party. An agent also cannot personally enforce contracts entered into by him on behalf of the principal. Principal's liability for the acts of the agent, Section 226. Principal liable for the acts of agents which are within the scope of his authority. Contracts entered into through an agent, and obligations arising from acts done by an agent, may be enforced in the same manner, and will have the same legal consequences, as if the contracts had been entered into and the acts were done by the principal in person. Principal's liability when agent exceeds authority, Section 227. When an agent does more than he is authorized to do, and when the part of what he does, which is within his authority, can be separated from the part which is beyond his authority, so much only of what he does as is within his authority is binding as between him and his principal. Principal not bound when excess of agent's authority is not separable, Section 228. Where an agent does more than he is authorized to do, and what he does beyond the scope of his authority cannot be separated from what is within it, the principal is not bound to recognize the transaction. Exception. Liability of principal inducing belief that agent's unauthorized acts were authorized, Section 237. When an agent has, without authority, done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by such acts or obligations, if he has by his words or conduct induced such third persons to believe that such acts and obligations were within the scope of the agent's authority. Consequences of notice given to agent, Section 229. Any notice given to or information obtained by the agent, provided it be given or obtained in the course of the business transacted by him for the principal, shall, as between the principal and third parties, have the same legal consequence as if it had been given to or obtained by the principal. Principal's liability for the agent's fraud, misrepresentation, or torts. Section 238. Misrepresentations made, or frauds committed, by agents acting in the course of their business for their principals, have the same effect on agreements made by such agents as if such misrepresentations or frauds had been made, or committed, by the principals, but misrepresentations made, or frauds committed, by agents, in matters which do not fall within their authority, do not affect their principals. Personal liability of agent to third parties. Agent cannot personally enforce, nor be bound by, contracts on behalf of principal. Section 230. In the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor is he personally bound by them. He can neither sue nor be sued on contracts made by him on his principal's behalf. Exceptions. In the following exceptional cases, the agent is presumed to have agreed to be personally bound. 1. Where the contract is made by an agent for the sale or purchase of goods for a merchant resident abroad/foreign principal. When an agent has entered into a contract for the sale or purchase of goods on behalf of a principal resident abroad, the presumption is that the agent undertakes to be personally liable for the performances of such contract. 2. Where the agent does not disclose the name of his principal or undisclosed principal, principal unnamed. When the agent does not disclose the name of the principal, then there arises a presumption that he himself undertakes to be personally liable. When the principal is undisclosed, the liability under Section 230 is of the agent only, and the principal cannot be sued in such a case. 3. Non-existent or incompetent principal. Where the principal, though disclosed, cannot be sued, the agent is presumed to be personally liable. 4. Pretended agent. If the agent pretends but is not an actual agent, and the principal does not rectify the act but disowns it, the pretended agent will be himself liable. Section 235. 5. When agent exceeds authority. When the agent exceeds his authority, misleads the third person in believing that the agent he has the requisite authority in doing the act, then the agent can be made liable personally for the breach of warranty of authority. Rights of third parties. Rights of parties to a contract made by undisclosed agent. Section 231. If an agent makes a contract with a person who neither knows, nor has reason to suspect, that he is an agent, his principal may require the performance of the contract, but the other contracting party has, as against the principal, the same right as he would have had as against the agent if the agent had been the principal. If the principal discloses himself before the contract is completed, the other contracting party may refuse to fulfill the contract, if he can show that, if he had known who was the principal in the contract, or if he had known that the agent was not a principal, he would not have entered into the contract. Performance of contract with agent supposed to be principal. Section 232. Where one man makes a contract with another, neither knowing nor having reasonable ground to suspect that the other is an agent, the principal, if he requires the performance of the contract, can only obtain such performance subject to the rights and obligations subsisting between the agent and the other party to the contract. Option to third person sue the agent or the principal. Right of person dealing with agent personally liable. Section 233. In cases where the agent is personally liable, a person dealing with him may hold either him or his principal, or both of them, liable. Consequence of inducing agent or principal to act on belief that principal or agent will be held exclusively liable. Section 234. When a person who has made a contract with an agent induces the agent to act upon the belief that the principal only will be held liable, or induces the principal to act upon the belief that the agent only will be held liable, he cannot afterwards hold liable the agent or principal respectively. Revocation of authority. Termination of agency. Section 201. Termination of agency means putting an end to the legal relationship between principal and agent. Section 201 provides for the following modes of termination. Revocation. An agency may be terminated by the principal revoking the authority of the agent. Principal may revoke the authority given to his agent at any time before the authority has been exercised so as to bind the principal. Section 203. However, the principal cannot revoke the authority given to his agent after the authority has been partly exercised so far as regards such acts and obligations as arise for acts already done in the agency. Section 204. Compensation for revocation by principal, Section 205. If there is premature revocation of agency without sufficient cause, the principal must compensate the agent for such revocation. Notice of revocation. Section 206. When the principal, having justification to do so, revokes the authority, he must give reasonable notice of such revocation to the agent, otherwise, he can be liable to pay compensation for any damage caused to the agent. Section 206. Revocation and renunciation may be expressed or implied. Section 207. Revocation of agency may be expressed or implied in the conduct of the principal. Renunciation by agent. Section 206. An agent may renounce the business of agency in the same manner in which the principal has the right of revocation. In the first place, if the agency is for a fixed period, the agent would have to compensate the principal for any premature renunciation without sufficient cause. Section 205. Secondly, a reasonable notice of renunciation is necessary. Length of notice is to be determined by the same principles which apply to revocation by the principal. If the agent renounces without proper notice, he shall have to make good any damage thereby resulting to the principal. Section 206. Completion of business. An agency is automatically and by operation of law terminated when its business is completed. Thus, for example, the authority of an agent appointed to sell goods ceases to be exercisable when the sale is completed. Death or insanity. An agency is determined automatically on the death or insanity of the principal or the agent. Winding up of a company or dissolution of partnership has the same effect. Act done by agent before death would remain binding. Principal's insolvency. An agency ends on the principal being adjudicated insolvent. On expiry of time. Where an agent has been appointed for a fixed term, the expiration of the term puts an end to the agency, whether the purpose of agency has been accomplished or not. An agency comes to an automatic end on expiry of its term. When the agency is irrevocable. When the agent is personally interested in the subject matter of agency, the agency becomes irrevocable. Section 202 states that where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. Effects of termination. Section 208. When termination of agent's authority takes effect as to agent, and as to third persons. Section 208. The termination of the authority of an agent does not, so far as regards the agent, take effect before it becomes known to him, or, so far as regards third persons, before it becomes known to them. Agent's duty on termination of agency by principal's death or insanity. Section 209. When an agency is terminated by the principal dying or becoming of unsound mind, the agent is bound to take, on behalf of the representatives of his late principal, all reasonable steps for the protection and preservation of the interests entrusted to him. Termination of subagent's authority. Section 210. The termination of the authority of an agent causes the termination, subject to the rules herein contained regarding the termination of an agent's authority, of the authority of all subagents.